Okay, welcome everyone. This is Tansen Fairmont, founder of Brilliance in Commerce, and House of Freedom Trust Director Randall will be joining us today. We have a very special event unfolding here, which will give more information on the science and the art of pure common law, sovereign, international natural law trusts from House of Freedom. So thank you for joining us. This is Wednesday, March 7th, 2018. This meeting is being recorded, and so there will be playback available and announced in our newsletters. Here are some of the projects we have for those of you seeing visually the screen. We have House of Freedom International Natural Law Trusts, Liberty Debt Elimination System, affiliations with a number of other special offers such as wealth from your FICO score, credit repair, gold purchasing concierge, offshore asset protection, Monaco Management Group, wealth management, cryptocurrencies, and so on. These are all topics that are discussed from time to time in our show. So I am a member of Board of Advisors of Monaco Management Group, and I've been a speaker on radio shows and former offshore investment seminars, and the author of the 1997 book, Sovereignty Consciousness, and a forthcoming new one called Cosmic Renaissance. Today, March 7th, we have our Brilliance in Commerce Trust webinar, and the next one will be in April 11th, and then May 9th, and we'll, for this foreseeable future, do these once a month. The website is ideally the one of the affiliate who referred you. So primarily, go to the link of the affiliate who introduced you to us. If you do not have one, then houseoffreedomtrust.com is one that can always be used in the future. So you put dashes between each of the words. So house-of-freedom-trust.com. All right? And I would like to share with you the newsletter information. Subscribe to the Brilliance in Commerce newsletter published by La Verite. And again, go to the houseoffreedomtrust.com site with dashes between each of the words and click on More, and then Newsletter Sign Up. For those who are here by telephone and need telephone support or don't have convenient access to the internet, our number is 360-200-7521. I'm seeing a comment in the chat here from Steve saying there's audio interference. However, we do have everyone muted, so there should not be any interference coming through. And now I see you say all good, so hopefully it's no problem. Thank you for the message from James. Welcome. Welcome, everybody. We'll get into an interactive part of the webinar later with questions and answers. I hope that you have the instructions from the newsletter on how to raise your hand. Those of you logged in by smartphone or computer with the visuals can click on the raise hand when we open up the webinar to questions later on. Then, of course, by telephone, I believe it's *9. The intro for those of you fairly new to this, to our trust, is just to give you an understanding, a brief overview, that our International Natural Law Trust is how the cultural creatives, the change makers, the conscious wealth managers, and contributors to the Golden Age are quietly transacting sacred commerce through an advanced asset protection instrument, previously a best-kept secret of the super rich. Peaceful people, and we use the word peaceful because we hope to invite, and thus far we've been very fortunate in attracting those who are involved in creating a peaceful world, can benefit from operating one or more of these trusts, which concentrate the best asset protection secrets of the elite into the fewest words and simplifies the language so as to minimize legalese and maximizes common politeness and understandability. These trusts can be operated in most countries anywhere in the world. Trust clients may become either trustees or creators, beneficiaries, and managers. These international pure natural law sovereign irrevocable trusts have no income tax filing requirements. They are infinitely flexible and can be adapted to any ethical, lawful, and noble purpose. They have a 100% success rate, meaning they have never been penetrated or invalidated in over 3 decades of use. This has been the trust of choice for those preparing for the global currency reset as the best vehicle for holding wealth and for preparing one's estate for generations to come. Heirs can be endowed with successorship seamlessly with no time delay, no probate, and no death taxes. Thousands of fortunate clients are quietly happy with these trusts. Very good. I would like to introduce you to Randall Hillner, our extraordinaire trust writer and speaker today. He's the director of the Trust Department at Brilliance and Commerce, founder of House of Freedom Trusts, founder of White Light Unlimited, trustee of One People's Public Trust, and creator of the International Natural Law Trusts. So at this point, I am going to turn you over to Randall and ask you, Randall, would you be so kind, please, as to first let me make you co-host here, and then I'm going to unmute you. And ask you to please give us a recap of the entire last, well, a very brief recap. I suppose I'm going to stop the share here, and then we'll see you. You're on the air. Please go ahead. However, you may not be on. Let me make sure you are. Yep, you're unmuted. Okay. So go ahead. You are on.
Hello.
I've been asking you to speak. You're on. You're on the air.
Okay. So, welcome everybody. This is Randall, the island of Kauai in the middle of the ocean. And I welcome you back. I know this is our third or fourth meeting, and we've been talking about the origination of trust work, where it came from, what it takes to be the creator. We talked about being a trustee. I think we talked about being what happens to beneficiaries. And what I'd like to talk about this week is what it takes to be a really good trustee. And basically, trustee has to be prudent and honest and make sure that the assets of the trust are well protected. It's a prudent investor rule is what they call it now. And that means is that it's your responsibility as trustee to take care of those assets. So if it's a piece of property and you're a trustee, then you need to make sure that proper insurance is on the property if you're doing an investment. And it's important that you as a trustee, you make sure that the investment is sound, and depending upon what the grantor or the creator of the trust desires, what kind of either very aggressive investments or very conservative investments or anywhere in between. So that is how it goes in a sense that way. So it's just, you need to be first, if you're a trustee, your first duty is to the trust and to the protection of the assets. So I'm not getting any slides, but I'll read some notes here and we'll go from that.
Randall, did you finish your recap of the last webinar?
Basically we talked, I think the last webinar was about the trustee powers, meetings of the trustees, and basic parameters for what it takes to be a trustee. And I just am starting today with the fact that it's the duty is to be of high standard and good faith, like any individual. If you're a guardian or you're an investment portfolio manager, you have to have high regard and good faith operating for the assets of that trust. That's the holistic aspect of trusteeship. In the beginning days, a trustee did it basically as a service to, in particular, to the knights that were going off to war. And nowadays, trustees can be paid a fee according to how much work they do for the trust. And I don't have any slides. You're not showing any slides to me.
Well, as soon as you're ready, we can start them.
Well, I'm ready.
Okay. We'll do that. Just a moment. Okay. Here's the first one.
The role of the protector.
Yeah.
This is an option that the grantor or the creator of the trust has. And the protector is the one that steps in if there's any kind of malfeasance or lack of prudence on the part of the trustee. Then the creator has the option to appoint a protector. Now, that protector can't be related to the creator or the trustees or the beneficiaries. So it's got to be, he or she has to be totally unrelated to all of those people. But that gives him a range in which he can act as a third party that doesn't have any investment in the trust at all. It would be like having a police force that would be there for your protection. That's what the protector does. And that can be appointed, the protector can be appointed right away, or it can come at any time. In other words, if you feel really confident with your trustees and everything goes right, then it's really an option. And if anytime you feel the trustees or one trustee is going astray, then the protector can come in and release that particular trustee or even both trustees, but they have to reappoint people that are, one can be related, but if it's say it's a non-related trustee that's not doing the right job, then he has to be replaced by a non-related trustee from that on. You always have to have When you have two trustees, one trustee has to be unrelated to the grantor. Both trustees can be non-related, but if you have one of your family members, then the other one has to be non-related. So just make sure your protector fits all those categories. That can be done at any time. Okay, next. Management. Okay, management is how you want to have the trustees take care of the assets in the trust. Again, if it's in real estate, the trustees, the trustees are not always money managers. So the trustees would go out and hire a money manager, hire him as a manager. Let's say there's a farm being done, then you would hire people to run the farm. Same with your investment portfolio. You would have him be a manager, manager for that particular role as the one that manages that portfolio. So it's just like any corporate environment. And you have micro management all the way down. Vice president, treasurer, secretary, all those things can be taken care of, and they're appointed typically by the trustees. Okay. Operating expenses. Okay, this is where it's really important to keep very good track record of what goes on with trust expenses. So obviously, if you need to pay some management fees, that's expected. If you pay some fees to the bank, but just make sure that it's all written down. And it's like keeping a book. It's like hiring a bookkeeper. You could actually hire a bookkeeper to take care of the expenses. Or when you write your own checks, then you need to note what they're for, and the important thing is not to commingle funds. In other words, the trustee can't use the trust expenses or the trust account to buy his own personal goods. What he has to do is both have to be has to be unanimous decision. Trustee cuts himself a check to himself, and then he uses that to pay for his own personal expenses. But any ordinary and necessary operating expenses can come out of the trust, and you just have to be a good accountant. You can hire an accountant. You can hire a tax consultant if you need it. So a lot of people they may have an LLC, and the trust is an owner or a partner with any other existing LLCs or any other companies. Then the accountant would have the expertise to make sure that everything's in order. Next. Okay, the duration of the trust is basically writing the trust states 21 years plus the lives in being. So a lot of people get confused on that sometimes. And lives in being means that, let's say the grantor is wants to retire and he has a family, has children, maybe even grandchildren, then the trust would continue in duration for as long as that child, that's the last child, is born. As long as he's still alive, then the trust would continue for 21 years. Then after that, let's say, well, because what happens is maybe those grandchildren were born during the grantor's lifetime, and they go on and they get married and they have children. Then it can go on for that, continue to go on for at least 21 years. And at the end of that, then the beneficiaries and the trustees can all choose to either extend the trust for another 21 years or to just dissolve the trust, and all funds in the trust would be given to all the beneficiaries in the ratio or the appropriate amount due to them, depending on how much beneficial interest they have, etc. And that's why some of the larger families continue to have multiple trusts, because say at the end of the 21 years, they want to continue, but they want to break it up. Maybe there's 5 families now that are still running their own, and they may take that appropriate step and each create a new trust to receive the assets that would be coming to them from the first trust. And it goes on and on and on. But that's the option everybody has. And Rockefellers and the Kennedys have obviously multiple trusts and multiple situations to handle the funds that they have. If you're an entrepreneur, I have a client that I talked to today, and he's expecting significant profit in his business, and he wants to make sure that his children and family, other parts of the family, are well taken care of as long as they live. So the duration is at 21 years after that last person dies, and then people have the choice to continue or to dissolve it. Next. Right into the questions.
May I just start with, get the question started with my own question. Why 21 years?
It's just the typical law book version that I've run across consistently. You could make it 25 years, but my mentor said 21 years is what most law books will dictate, talk to you about. It has to have a timed ending, and then it can go from there.
So everyone, you have 3 ways of raising your hand. If you're on the telephone, *9. If you're on the video, click on the raise hand icon or type it into the chat. And while we're waiting for questions to come in, okay, here's one. PA, you are unmuted and you're on the air.
Hello. I have a question. I have put together, or I had someone put together a trust. I'm very new to this. Now I'm thinking that I don't want to continue with this trust. Nothing has happened with it. It has not been populated. It simply has myself and someone else as a trustee. And is there a way to dissolve a trust once you have created it?
Sure. If there's been no activity, then the trustees and the beneficiaries can just decide to dissolve the trust.
Okay. I mean, I haven't even informed the beneficiaries that they are the beneficiaries.
Okay. If nothing's been done, then I would just have you and the trustees just dissolve that particular trust. And are you looking
By
another one, or you just want to
well,
dissolve?
I'd like to dissolve that one and perhaps use this method, instead.
Okay.
Is that a statutory trust?
No, it does say it's a constitutional common law trust. I think the intention was good, but I'm not comfortable with the way it's set up. And a pure private, non-statutory, unincorporated contractual business trust organization. There's a few people out there throughout this process that have been setting up their own trusts as protectors and grantors. And now that I'm starting to get a little deeper into it, I'm not sure I want to be involved in those particular instruments. So that's why I'm just asking you these questions. What legal status is what's the standing if nothing has happened, if no one else has been informed about it? There's one other person besides the grantor who would know about these things that I'm doing. And I mean, I know they're supposed to be confidential, so I'm not releasing any further information. But it seems to me, and especially if an EIN has been applied for, that there is a track record for this as a business entity. So I just wanted to know what legal ramifications would happen if I drafted a minute with the other two people involved, the grantor and the other trustee, and simply draft a minute and dissolve the trust. Is that the way to go about it?
Yes. You and the trustee would create a minute, say it's no longer, we never used it. The trust was never used, has no assets in it. Nothing was done with it. And it's been decided by the trustees and the grantor to dissolve the trust. That's what that's what you would do at any time. Let's say at the end of 21 years, or any time in between, if there's really no interest in continuing the trust, the trustees just create a minute or an amendment and say there's no activity, and we have decided to just dissolve the trust. And if there's anything in the trust or nothing, if there's nothing in the trust, nothing has to be paid out anywhere. If there is any asset in the trust, then it would be paid out on a pro rata basis to any beneficiary.
Okay. And actually, I have two of these type of trusts. One of them says it's active for 200 years, and the other one is 99 years. They arbitrarily just wrote that into the trust. So I'm just curious.
It's just an arbitrary number, and as long as the two trustees, the grantor, agree, then it's an amendment or a minute that says there's no further interest in continuing this trust, so we hereby dissolve it.
Okay, very good. Okay.
Nobody has to be notified because it is a private contract. And the EIN number is strictly for banking purposes. There's no need to contact the IRS. Doesn't really matter. So it's a private contract. You dissolve it, and it's put away, and you can burn it or store it.
Okay. Okay. Very good. Thank you so much. I really appreciate it.
You're welcome.
Thank you, PA. Randall, is there a explanation for the reason for not making a trust go into perpetuity?
It just can't be done. It's one of the major laws for trust. So it has to have a time frame. It can be renewed, but it does have to have a limited time frame. And that's why we say lives in being plus 21 years.
And why is that? What makes it a sham if it goes into perpetuity?
it will be in discord with any trust laws. So if anything, the courts would all take you to task if anything was going on with the trust and it ever went to court of equity. It would just be dissolved. The court would disallow it.
In other words, they would consider it invalid because.
Just because that's one of the laws on a restatement when they rewrite the law books or rewrite the code called the Uniform Trust Code, they specifically say that it wouldn't be a trust if it's in perpetuity. Perpetuity is something for like a 501c3 or a 508 church or something like that, but a trust has to have a limited time period.
Okay. All right. Next, we have area code 260. You are unmuted, and would you like to state your first name and your question?
Yes, my name is Jay.
Hi, Jay.
And, I don't really have a question, except I do have a comment that may be advantageous to everyone on the call. A couple of weeks ago, I got a newsletter from you, from Brilliance and Commerce, and it suggested that one of my resources might be the art of passing the buck. And I spent the money and bought myself 3 copies of it, and I got it over last week, and I've started to reading it. It is fantastic. It gives some history of trusts, and it lays a basic foundation. So I would suggest that anyone who feels they don't know enough about their trust and who's going to be working with the trust and in the trust, either as a trustee or a manager or whatever, they should read this material in passing the buck. Now, it's kind of expensive. I think it's $45 or $50, something like that. But anyway, I think it is very good. And that's one book I will probably read from front to back. I'm so far gotten into chapter 6 or 7, and I'm excited about what's there. So anyway, I just wanted to make that comment.
Thank you so much.
I'll ask you a question. Do you have the second volume?
No, I don't have the second volume. I just bought 3 copies of the first one because I want my other, whoever turns out to be my other trustee, and a couple of other people that will be in my team to read that. And I do eventually plan to get volume 2 because of all the case law and stuff that's they say is in the back or in it.
Right.
So I will be purchasing it. It's kind of expensive. It's like $600 for the second volume. So
right. It's I've read them. I have both volumes, and I've read them twice each. And I have spent another $3,000 in law books just on trust. So there's extensive material out there. Passing the buck, the first volume, gives a general overview, and I think is a good source. The trust manual, the manual that Townsend has written, is also really good to start with. Keeps it simple. Volume 1 of Passing the Buck. There's other, well, the more intricate you want to get, then you can spend as much money as you want. But then you have to stay updated with it. But that's a good place to start. So thank you for that comment.
Yeah, thank you. I just wanted to make that because I've been impressed with what I've read so far. Thank you, guys.
We really appreciate it. Thank you so much.
You're quite welcome. Thank you.
Okay. We have in the chat, there are a number of questions. Are there classes specifically that teach how to be a good trustee?
Sure, go to law school. No, I think
this is part of it right here.
this is part of it, what you're getting now. And like I said, the books, a couple of the books, the trust manual that comes with a trust, I think Tanzan actually has included most of it in his long trust book. And so you just keep going over it. And I guarantee when you get your trust, if you read it, you're going to need to read it 10 times before you really get the essence of what it all means. So there's so much information in the trust document itself that it will keep you busy for a while. But getting outside research done also helps. You can go on the web. There's a couple of websites available that give general views, but a lot of the stuff on the web is statutory. So be careful how you interpret anything that's statutory, especially that's why I recommend that you not have a lawyer as a trustee, because automatically becomes statutory for the fact that the lawyer is under statutory obligation. His first obligation is to the court and not to the client.
You mean a bar licensed attorney?
A bar licensed attorney, that's usually, that's what I would call a lawyer.
Well, we have what we call common law lawyers who are not bar licensed.
Well, in that case, yes. In that case, maybe, if you can find, if he's versed in trust law, then fine. If he's just a scholarly lawyer, he may not have any experience in trust law.
And maybe the Passing the Buck book would be good too for those who want training, huh?
I think the Passing the Buck is good. It gets a little complicated. Volume 2 is very complicated, and it takes some minute understanding of how that works, although that author has got a pretty good understanding. So yes, that would be good.
All right. Next, about the duration of the trust, Steve asks, so is it 21 years after the last grantor dies?
There's only one grantor. But there may be many beneficiaries that go out for all right, let's go back to that.
Well, wouldn't it be, let me just interject this, wouldn't it be the 21 years measured from the inception of the trust when it's first written and created?
It depends on how many people are already alive in his family. The grantor has children, and they may have children. They may even have grandchildren. So it's 21 years after that grandchild dies.
Of the grantor?
Yes. So it's not 21 years after the grantor. And once the grantor dies, it's all up to trustees and the beneficiaries to keep it going or to dissolve it. So people have asked me, well, can you replace the grantor? No, the grantor basically is the one that creates the trust, and he relinquishes all control of the assets that he puts in to the trustees who hold legal title to that asset, and the beneficiaries have equitable title or beneficial interest. So there's only one grantor.
All right. And Sarah writes, I have no children and no husband. That means that when I die, the trustees should renew the trust in 21 years?
Only what would they do with it if you don't have any beneficiaries? If there's no beneficiaries, then there's really no need to continue the trust. So you could have it part of your estate, or you could say at the end of my time, then I would like any assets to be donated to such and such, or whatever you'd like to do with it.
And she continues, and the process of renewal is to just make a minute order stating it has been renewed and no authorities are involved in that process, correct?
That's correct.
You are the authority.
Me or the trustees?
The people involved in the trust.
Yes.
Right.
Yeah. No, it's a private contract. We have an unalienable right to contract. So it's you as a grantor or a trustee, trustees, and then beneficiaries.
Rita writes, please repeat the title of that book he recommended. That's Passing the Buck by the Charles Arthur Organization. And Rita, if you're not already subscribed to the Brilliance in Commerce newsletter, do so. And I'll make sure to occasionally repeat the information about where to go to get that book. And we've put it, we haven't really posted on our website. Do you remember the website of where the Passing the Book series is available, Randall?
It's a Charles Arthur website. Oh, there it is right here on my screen. Passingthebuck.com. I would also highly recommend going there and subscribing to their newsletter. It comes out every couple of months, and it's about maybe 5 or 6 pages. There's always a tidbit or 2 or maybe 3, sometimes 4. Sometimes I've read them and I've underlined it 4 times. So their newsletter is well worth it too. I believe it's only $80 a year. So, and you get it on your email. You subscribe to it, and then you can either print it out or you can just keep it on your computer. I print it out. I have them all stacked in a binder, and I go through them whenever I need to look for a certain item that I know is in there somewhere.
Next question, Edward writes, you mentioned 508C. What is your opinion on them?
508 is just a nonprofit church, but it takes it's not my forte, and
it's a statutory.
No, the 508 is a church, and it's not like a 501c3 is a statutory church or organization. A 508 is non-statutory, but it needs to be set up properly.
I guess by asking your opinion, he's maybe asking how do you think it compares to the trust that we usually use?
It's a whole different scenario. It's a whole different ballgame. Apples and oranges. You don't, unless you're really actively running a church or a nonprofit process, you don't need it.
Sarah, I don't know if this is a complete question. She just says beneficiary is another trust.
It could be.
Yeah. Can do that. And SK writes beneficiary can be other family members.
Absolutely.
And which has a humanitarian mission. This is back to the trust.
Yeah, you could. The trust can give away any amount of money that it wants to anybody or any project.
The website of the book website that SK has put us in the chat is www.passingbucks.com. So that's where the newsletter and the Passing the Buck book is available.
Right, and I think I wrote a bibliography, and do you have that on your website, or have we included it somewhere?
We should put it on the website, and it has been sent in newsletters, but we'll send it again.
Or at least post it somewhere, bibliography on your site, whatever you want to do.
Right.
But it's Passing the Buck is in it. I have probably have 5 or 6 different sources of information on how to get more data.
You
But
know, a good place to put it would be at the end of the manual that you wrote, maybe right at the end of that for trust clients for further.
trust manual, that's a great idea.
Yeah.
I'll have that.
Have your secretaries do that.
Well, but I would also have it for people to see what they're in for as part of when they go and look on your web page and start this process, that there's a tremendous amount of information out there, and I'll have it on my trust manual, and it'll be readily available between the two of us.
Okay, next question. Myra writes, at what point do you recommend establishing a bank account for the trust, especially in light of the upcoming GCR?
If you're mostly setting up the trust to receive the exchange, RV exchange, then I would not open up an account. You don't need it. All you're going to do is pay the bank $10 or $15 a month for a checking account. So there's no need for that, because when the exchange happens, it's going to be a whole different process. And a lot of banks won't be able to handle the potential amount of money that you'll be receiving, depending on how much currency you have.
Unless there are other uses for the trust before
Sure.
the GCR that the person may have, right?
Well, sure. If you're going to put your house in trust, you're going to have a bank account to pay operating expenses and management fees and et cetera. So yes, if you are using it other than just waiting for the RV, then do that. But you're going to need to take both trustees with you. The bank may or may not, if you're the grantor and the manager, the bank may or may not allow you to be a signator on the account. Some banks are really easy about it. I know Wells Fargo is a stickler for only having the trustees be the ones that sign the checkbook, but that doesn't mean that you can't work it all out. In other words, the trustee could sign a number of checks in advance, and you could hold the checkbook and use it for what you need it. But every time you do that, I highly recommend that you email the trustee and say, I'm using this expense for this particular process that involves the trust. And then, as a manager, let's say if you're the grantor and you have two other trustees, you can pay, the trustees can pay you as manager to take care of your personal affairs. In other words, rather than get a beneficial interest, you get beneficial interest at the end of the year. Let's say on a monthly basis, you need so much money from the trust, then they can pay you a manager's fee as well.
Okay, Robert writes, is beneficiary limited to actual family, or are others included, such as friends you choose?
Of course, anybody you want to have as a beneficiary is allowed.
Basically entirely up to the grantor, right?
Absolutely.
That can be organizations, other trusts, charities. It can be family, it can be friends, anything you believe in that you want to see supported, right?
Sure. Especially if you're in it and the RV, for the RV, and it does happen, then you're going to have enough funds to pass around to a lot of people.
And for anyone who's listening and doesn't know what we mean by GCR and RV, we're referring to the global currency reset and the revaluation of currencies. Okay. James says, I think the 508c is an organization with a tax exception as opposed to one with a tax exemption.
I would say that's not true. It's totally tax exempt. The
We might,
501c3 has to file paperwork. It's basically doesn't have a tax, but it must file paperwork every year. Whereas the 508 does not have to file any paperwork at all.
okay. Josanne writes, if I want the full control of my trust, can I use a friend to become the grantor of the trust while myself choosing the role of trustee?
Yes, as long as there's another trustee with you and you're not the only beneficiary.
And the other trustee is not related?
Correct.
Joel writes, will there be a recording? I'm not sure if what you mean. You mean a recording of the trust on the public record? If that's your question, then Randall, you could address that.
No, you're not going to record anything with anybody. All you're going to do, and when you get your trust document, you also get an attachment that allows you to go in a form. It's all written out, and you just go online and get the EIN number, and it takes about 10 minutes.
Now, if there's a transfer of real estate into the trust, some may want to post that on the county recorder or something, yeah?
They have to, yes. In order to transfer title or anything like that, that would have to go to the county recording office.
What is the absolute rock bottom minimum information that must go at the county recorder as to the name of the trust, as to the entity that the house went to? Would it just be the name, perhaps? Would the EIN need to be included?
Yes, yes.
So the name of the EIN?
I don't know. I've never done that, but I would imagine they're going to want an EIN number. I don't know. It depends on your county, but the trustee will have to do the signing on the changing of title.
But it may not be necessary to even tell the county recorder that it is a trust. It may just be the business name, the name of the trust without saying it's a trust, right?
It could be. I don't know. It depends on the county, what the laws for that county are.
Okay, but otherwise the trust doesn't get recorded anywhere, the existence of it.
No.
Yeah. And even the IRS, when you get the EIN, you don't give them much information about it. They don't know.
Well, they knew who the responsible party is. When you file online, one of the spaces is for the name of the trust and current address, the trustee, and then the responsible party, which would be the grantor, and the grantor would supply their EIN number, and then it goes on whether you're going to have employees or not, and that's about it. The instructions are really clear about how to set it up, but that's all there is, and you're just filing for an EIN number so that the banks are, well, I'm not going to talk about that collusion that exists out there. Banks won't allow you to open up an account without a number, whether it's personal or a trust.
Well, everyone, I must let those of you know who have not already acquired a House of Freedom Trust that Randall has put together a very, very excellent instructions, several pages of instructions on exactly, precisely how to apply for the EIN, what boxes to check, what to say, what not to say. So really, all the IRS knows is that it's an irrevocable trust. Yes. And that word irrevocable is applicable both to statutory and non-statutory trust. So there's no indication anywhere that it's common law, that it's pure, that it's any of that.
No, it's just an irrevocable trust. And that's all that's needed. It's very simple. And that's all the record keeping there is, except for you and the trustees need to keep minutes and amendments and adjustments and anything that you do. Any actions taken need to be recorded, and it goes from there.
Pam writes, do you handle international trusts indentured in places such as Belize? And we will first say that this trust already is international, and that's why we put the word international in the name of it. It has no limitation as to its jurisdiction. It's basically global. But do you want to address additional points on that?
Well, I think some countries are don't have common law, but I think there's no country that I know of that doesn't allow for private contracts. I think private contracts exist all over the world, whether it's shaking hands or writing out a document, whether you use the word trust or private contract doesn't really matter. So we have clients in Europe and in Australia, in South America, Central America, Canada. So they're spread around.
Basically, this is just my personal opinion. I don't think someone needs a trust in a friendly jurisdiction like Belize that is under their laws, because that's statutory, even though it's friendly, maybe it's tax friendly, has no tax requirements, but it's still statutory. And they could change in their parliament or their Congress the laws next year and invalidate it or change it or make it more restricted. That happened in the Bahamas. It's happened in many places.
Right.
So why go with a statutory trust even in a good place when you could use one of our House of Freedom International Natural Law Trusts that no Congress and no Parliament can outlaw or change?
Right. Yep. There's no reason to have something that's just very local, and the location of the trust can happen anytime, anywhere you want to go with it. All you do is you note the change of address in the minutes. If you go to live somewhere else out of the US, then you take it with you, and you'll have an EIN number for it. And the country you go to might, depends on the bank again, they might want a different number or they might not care. It depends on where you're going. I don't know international law that well.
Yeah, ladies and gentlemen, a lot of countries have accepted the American IRS EIN on a trust to open an account just because, I don't know, they respect the U.S. or something. They don't care. They don't need some local number. It depends on the country and depends on the bank, like Randall said.
Right. Oh, and I have a client that been addressing. She has one of our trusts, and I thought for sure she lived in France. She invited us, Marissa and myself, over there, and she said, "Yeah, we have." She has her trust going over there, and then she said, "No, where do you live in France? We're thinking about coming and maybe visiting." And she said, "Oh no, I've moved to Britain." So she just moved across the channel and went to Britain, but so it must work over there as well. She said they were under Napoleonic law in France. I said, "Aren't you under civil law?" And she said, "No, Napoleonic law." So it may be a little different over there, but she didn't have any problem with it.
Okay, a gentleman named Mel says, please give me your opinion of SSM, self-supporting ministry.
I wouldn't know anything about it. That would be it. That would be like doing a 508. If you're an ordained minister, my wife is an ordained minister, and she could create a 508 church herself if she wanted, because she does all kinds of esoteric things, and she became a minister, and so she can do that. She can lay hands on people without having the government come down on her.
But basically, a minister can do the same thing under one of these trusts as well, yes?
Sure. If you're a minister, then you have that ability to do that.
Okay, David writes, can you pledge income from the Social Security number job to the EIN number trust without commingling?
Um, it depends on the job you're in. If you're in an employee situation, then you can't do that. You have to take it yourself and then put what's left into the trust. But I don't think the employer will let your employee situation go to the trust. That would be dependent upon your whoever owns the company.
Yeah, usually larger companies will not do it. Now, if it's a
Yeah.
small little firm with only 5 employees and the boss knows you well, he might be willing.
Right. Yeah, he would cut a check to the trust with its EIN number, but then you wouldn't have any Social Security insurance or um, stuff like that. So you have to decide. That would be a case by case decision.
Yeah, and then the trust could turn around and cut a smaller amount back to the individual, perhaps.
Yes, and that's
Okay.
why it's good if you're going to run a business. If you have your own business, that you have the trust be the one to cut you a check, and then your amount of income can be minimal, so you have minimal tax liability.
Anthony writes, can we have as many of these trusts as we can afford?
Absolutely. However, uh, I would have to talk to that person first, or to see how he wants to do it. Usually, when you create second and third trust, well, you could do it yourself. If you do it yourself, you could do. It depends on why would you. Okay, so a question goes back to you. Why would you need more than one at this point in time?
Ask the Rockefellers, who were rumored to have had 7,000 of them in the early 90s.
Well, that's a different situation. And that's probably because they broke it up. They broke such a large amount of funds that they started to create new trusts. And they had, how many beneficiaries did the Rockefellers have? Probably 1,000. Same with the Kennedys. Just kept branching out. And that's why you keep on creating new trusts. But I think for a single person, yes, you can have as many as you want. But I would ask, how much money do you have, and why don't you use that money? Sure, we'd love it if you bought 5 trusts, but I would suggest that you save part of that as an investment portfolio as well.
This question is addressed to me. Many times you say a document may be available for free from the link of whoever referred me, but I really do not remember how I came to get the email. Maybe an anonymous person wanted to lead me here. How can I get your link to use to access the free documents? So for those who do not have a referring affiliate, all you do is simply go to brillianceincommerce.com. Brilliance, BRILLIANCEIN, commerce is COMMERCE.com, and go to the trust section. Or if you want to go directly to the trust section, use houseoffreedomtrust.com, which has dashes between each of the words. That goes directly to the trust section, and then there's the free download there of the ebook. And on Amazon, it is for sale. So you can buy the same ebook on Amazon. I think that's what you're referring to, but to get it for free. And I honor our affiliates. I love our affiliates. I'm very grateful to them. That's why I usually refer people, if you have a referring affiliate, please honor that person and use their link. But if you don't have one or lost it or, then just use our generic website. And Sarah says, I was trying to say that the Natural Law Trust, which is set up as a mother trust, has a humanitarian mission as its purpose, and the beneficiary that has been set up for that mother trust is another trust that also has a humanitarian mission. So that's why I would not want the trustees to dissolve the trust after I die. There are no children or other people as a beneficiary, and I would want the mother trust to continue until there is no money left in it to serve the planet.
Sure, absolutely. Or you could have the trustees could just have all of that funds that are in the trust be put right into a number of one or more humanitarian projects, and then the trust could dissolve on its own. Or you could save it and there may be some new humanitarian project that the trustees want to fund. But if you dictate it, it's going to be in your directives to the trustees upon my demise that this is how I want the ending to go. It's kind of like a will, but it doesn't have to go through probate.
Right.
That's what this trust will do for you and your estate, is it will never have to go through probate or suffer a death tax. They tax you going in and they tax you going out.
This question says from Peter, where can I get condensed information about the GCR? Do you help people prepare to benefit for those events? Randall, Sarah publishes a newsletter about that. Would you like me to refer that question to her?
Sure.
Sarah, if you don't mind, I'd like to unmute you, and would you like to give this person some information on your newsletter? If you are there, Sarah, you are unmuted.
I'm here. You want me to unmute?
You are already unmuted. At least you were.
Okay. Am I there?
Yes, you're on the air. And so Peter wants to know where can he get more information on the GCR and how to prepare for that.
I have a no-charge newsletter that has been educating people since 2006 related to all of this. I could put maybe an email address here that they could email me to, or?
Yeah, we only have around 60 participants on the line. I don't think that everyone's going to write to you, so you won't be overloaded.
Yeah. I'll put that in the chat. I'll
Okay.
just say for the newsletter. And what I would say is it's a private, no-charge newsletter, but a person needs to be referred to be on it. And you could just say to the, from the Brilliance in Commerce Natural Law Trust webinar. And I would accept that.
Thank you very much. And everyone, Sarah writes a very professional newsletter, very professional, very responsible, very well researched, no nonsense, none of these false prediction dates like it's going to happen next Tuesday and then it not happening, So I just have to compliment you, Sarah, on the quality of what you've been putting out.
Thank you. That's very kind of you. You want to mute me again?
If you're done, okay.
Yes, thank you.
Thank you. Okay.
I see a question here. It says, I want to start an independent publishing company. I want to put a book I'm writing in the trust. Would the company do better operating as a business trust and I turn over the rights of the book? I would have you suggest you create a trust, and it would, excuse me, it would be your publishing company and the publishing company and the trust would own the rights to the book, or you can own the rights to the book and have the publishing company and the trust be doing the work. Excuse me. Anyone else? Thank you, Sarah, for offering your newsletter. Okay, anybody else? PA? I see
Did you
your
get this
hand.
question? You don't need to have a trust for each property you might own? Pam asked this question.
Depends on the value of each property. But again, yes, if the property has any value, if you have any, if it's all under lien from the bank, then I wouldn't worry too much about it. But if you do have a fair amount of equity in each home, then I would definitely suggest 2 trusts, and each house or piece of property would go into its own trust.
David writes to the commingling question. I tried to change my W-4 from my SSN to the EIN, and they would not accept it. It was a large truck driving company.
Yep.
Yeah, that makes sense.
They don't want that.
Yeah, they want to keep their slaves.
Well, they're under the scrutiny of the IRS a lot more than the individual.
Right. Hulda writes, hi, Hulda. I was understanding that you need one trust for the holding of all the funds or the mother lode of the money, and then you need another trust for philanthropic purposes.
No, you can, because the trust can can donate as much as it wants to any project. So you could, but you just donate to the project. You hold the funds in one trust, and there's no need to put the humanitarian projects in another trust, especially if there are other people involved.
I think that thinking comes from lesser quality, weaker trusts out there that need multiple layers in order for the protection to be increased. Would you think, Randall, that we don't have so much need for that layering because these trusts are already rock solid and bulletproof?
Well, as I said a couple of weeks ago, that a trust can be sued and it can sue. So they're bulletproof in the sense of they're not going to break down under pressure. But if let's take the instance of 2 pieces of property. We just talked about it. So I suggested, yes, if there's equity in each house, then I would suggest each one goes into its own trust. Because if they're in one trust, and let's say somebody falls down on one property and sues the owner of that house, then if that other trust is owned by the same person, if the other property is held by the same person, then they would try to attach both properties. So that's where the 2 trusts would be very viable.
Thank you. That's a good answer. Arian writes, I want to start an independent publishing company. I want to put a book I'm writing in a trust. Would the company do better operating as a business trust and I turn over rights to the book to the trust?
Well, the trust can do any business that any person can do. So that's the reason I don't call it a business trust anymore. because it has the right to do what any other natural person can do. So it's a matter of choice. You could have the trust own the publishing company, and then you work for the publishing company, the company's in the trust, and all the profit would go into the trust, and then you would be paid a commensurate value, and then the trust could retain the profits, more profit.
Yeah. Let's see. A friend offered a revocable common law trust as a best option in preparing for exchange. Your opinion, please?
Oh, a revocable trust means you're the grantor and the trustee and the beneficiary, and that gives you no separation from your assets, and it's all up for attachment. Revocable trust, all revocable trust does is it avoids probate. There's no asset protection. There's no separation between in a revocable trust. Usually they have like AB revocable trust, the husband and wife. So if the husband dies, then the wife takes over the assets of the trust and vice versa. But it doesn't really give any separation, so it's not bulletproof.
Yes, Mel, for your benefit, I'll review something that we discussed in a previous webinar. I took this trust into Chase Bank back in 2013 to open an account, and they refused to open it. And their reason was because the settlor did not have signatory power over the entire trust. And that means our trust is irrevocable. It means the settlor signs off and has no further revoking power, or
Right.
he cannot revoke the transfer of assets back to himself. And I called up Randall and told him that, and he almost fell off his chair laughing, saying, of course they would like to have it revocable, because that way it's a lot easier to penetrate.
Right. You got to shop around sometimes for a bank that will work with your trust.
Yep. And the ones that says yes turned out to be the best ones.
Sure.
If someone gives you a valuable asset and you transfer it to a revocable trust, and then you have a judgment against you, that judgment can force you to revoke it back from the trust and give it to them. So that's why I don't think they're worth the paper they're written on.
Exactly. They'll just attach the trust.
But if it's irrevocable, like ours are, then it's inaccessible, no matter if there is a judgment.
If there's a judgment on you, then the assets in the irrevocable trust cannot be penetrated.
Right. Lisa says, what do we do if our trustees are duds?
Dead?
No, duds, D-U-D.
Oh, point a protector and get rid of the duds. And hire some lively cats.
Yeah. James says he has to leave early, but he wants to thank us. He says, thank you, Tonson and Randall, for the seminar, and Sarah for the newsletter. Have a blessed day. Thank you, James. That's really appreciated.
Thank you very much.
David writes, so can I put my SSN income into the trust without commingling? I think that's similar to the question we already answered.
You can't do it.
No.
No, you're... Again, are you talking about the fact that you work at a job?
I guess that would be what he's referring to when he mentions the SS income. Unless, perhaps he creates a special contract with the trust whereby he's performing some services and the job he's working at is willing to pay the trust under some sort of service agreement or something.
Yes. If he can get the company that he works for to have a mini contract with him, and they agree, then yes, that's very doable.
I would think that you would have to change it from an employee relationship to an independent contractor relationship.
Yes.
Right. You do the same work for the same pay, but with different paperwork.
Most big companies don't like to do that.
Right.
I mean, if the company does contract work, then you could easily approach them and say, I would like to do my work on a contractual basis versus a salary. But if you're on an assembly line, they're probably not going to let you do that.
Right. This one says from Margaret, if I transfer, say, 5 units of beneficial interest to a beneficiary, can I change my mind later and transfer, say, 2 or 3 of those units back to myself?
Yes.
The trustees would do this, of course.
Yes.
Okay.
But I would caution you to make sure in the beginning that that's how much you want to give away to that person versus trying to take it back. It's like trying to take a lollipop away from a 5-year-old.
This person says, how about if you're already retired? How can you handle the SSN income?
I'm assuming you're talking about a retirement income from a company or from just Social Security.
Good question.
So that's what I would ask back. Is it Social Security?
Well, I'll say that, I became power of attorney for my mother. She's in her 90s. And so I handle her affairs, and her Social Security income gets deposited into the trust account at the bank. However, it's still payable to her.
Yes, it's in an account in the bank for her caretaking.
Yeah, it's a family trust, and
it's probably revocable. It's probably revocable.
No, no. It's one of our irrevocable trusts.
Okay.
And the Social Security Administration, as you may know, back in 2013 made it mandatory to give them wire instructions. They would no longer send checks for Social Security.
Right.
And so I gave them the trust wire instructions, and they've been using it.
There it is. So you slipped one through the slot.
Now, what about a self-directed IRA or 401k, something like that?
It depends on how it's set up and who's handling it. I think had a client that wanted to do that. She had the trust already, and then she wanted to know if she could put her 401 in it. And I said, you're going to have to go to the people that are controlling your 401 and see if they would do that. And I didn't hear back from her, so I don't know what the outcome was.
PA, did you have another question? I see your hand is up.
Yes, thank you so much. I wanted to know a couple of things. Unfortunately, I live in a remote area, and I have to listen to this on my phone. So could you possibly give me Sarah's newsletter email? And is there going to be a recording of this session that will be on your website?
Unfortunately, we have not gotten it organized with our webmasters to post these on the website. That is one of the forthcoming jobs. We've got a list of things my webmasters are working on, but yes, in the future, we'll be. In the meantime, be sure to be a subscriber to our newsletter. And yes, the playbacks are always published in the newsletters. Are you a subscriber to that?
Yes, I am. I'm recently subscribed.
Okay, so thank you. You will see the playbacks announced in the newsletters, and the email address for Sarah is SARA
Okay.
M as in Monday,
Okay.
A-T-T-O-O,
I'm sorry. SARAM and then what? Okay.
A-T-T-O-O-N at gmail.com.
Okay. That last letter is an M or an N?
It's an N as in Nancy.
Okay. Thank you so very much.
You're welcome. And let's see, someone else wrote about a good source of global currency reset information, mentioning the Global Genius Trust. I'm just looking for that. Apparently, there's an email address there, PA. It's Dan, D-A-N, at ggtrust.com, as in global genius. So Dan at ggtrust.com. Apparently, they have good RV GCR information.
Okay. Great. Thank you very much.
You're welcome. Thank you. Okay. Randall, any further final comments? Oh, here's another question. From Mark, how crucial is it to place our pre-RV currencies into the trust before the exchange process begins versus allowing the bank to or redemption exchange center to place our post-exchange monies into a temporary trust and then transferring the assets into the natural law trust?
That's a very good question, and I always say do it now because it goes in at current value, and so it's a non-taxable event. And so when you go to the exchange, then it's the trust that owns it, and there's no transfer fee or there's no big all of a sudden clump of money going into the trust. The trust is the one that's going to do the exchange, not you.
Yes, that's my opinion as well. And it is, now Randall does provide a exchange of currency document to the trust, and it's recommended to get that notarized before the RV.
Yes, you want to have it dated and notarized so that it is placed in the trust before the RV happens.
Mm-hmm.
There's two documents in the trust that need to be notarized. One is your amendment example for the currency, and the other one is the trust certification. With those two notarized, then anybody looking at it, any bank would know that the trustees are who they say they are, and that the currency is owned by the trust.
So, any any final thoughts?
I have none. I'm just questions are easier for me to continue with and maybe expand on typical topics or atypical topics. So please feel free to connect with Tanzan or start to get the trust process happening, and then you'll have access to me from there.
Lisa writes, but if an exchanging bank has refused to open a bank account for the common law trust, how can we exchange with them?
I don't think the exchange center is going to be very different than a bank. And I guarantee when the exchange happens and you're now a red carpet client, that the banks will welcome you right through their doors. You'll have a priority preference.
Yeah, if they won't accept an account for the trust and they realize you're getting a large amount of money, I'd probably walk down the street and go somewhere else.
Yeah, I don't think you'll have a problem. I think they'll take you straight up to the 13th floor.
The lucky floor.
Yes.
Everyone, I'll just leave you with the Aesop's fable of the wind and the sun. The fable goes, as you may know, that there is this argument going on between the wind and the sun about who is stronger and who is more powerful. And the wind says, look at me, I blow things, I force things, things move, things fall over, things fly through the air. I'm very powerful. And all you do is just spread a bunch of light, you know? And the sun says, well, okay, let's put it to a test. You see that man down there walking on the road with his cloak on? Let's agree that whoever can make him take his cloak off will be the designated the stronger of the two. So the wind agreed. So the sun says, all right, you go first. And so the wind blew and blew and blew, and the man just pulled his cloak around him more tightly. And the wind blew some more and blew some more and made a big bluster, and the man almost got blown off the road, but he tightened his cloak and he just wouldn't let go of it. And he pulled it really tightly, and finally the wind gave up. So then the sun came out from behind a cloud and started shining really warmly. And first the man loosened his cloak, and then the sun shone some more, and the man loosened his cloak some more. And pretty soon the sun got really hot, and the man took his cloak off. So the moral of the story is persuasion and kindness are more powerful than force. And may I just say that this is a principle on which the trust, brotherhood, sisterhood operates worldwide. We'd rather trust our friends, our family, our trustees, or even ourselves, if we are the trustees, than the institutions of force that have caused such a plague on humanity.
I agree with that.
Randall, thank you so very kindly. We really appreciate it. Your knowledge is great. We're getting a lot of wonderful comments. I haven't even mentioned all of them. You can see them in the chat. A lot of people saying it was great stuff. Thank you, another outstanding service of humanity. Hip, hip, hooray, and so on. So thank you, everyone, for your wonderful cooperation and compliments and participation. And
Thank you
we're
all
going to...
for listening, and thank you for the great questions.
Yes, absolutely. Absolutely. Okay. Well, next month, what is it? April 11th, I believe. We're going to have another one, and we'll announce it in the newsletters. So we'll look forward to our private communications by telephone and email. And in Hawaiian, we'll say thank you, which is mahalo.
Mahalo anui loa. Thank you very much.
Okay.